Welcome to the first of 3 videos of the series Insider Reporting. This video is designed for new reporting insiders or those seeking a refresher. Information for reporting issuers can be found in the Insider Reporting Basics for Reporting Issuers video. And for reporting insiders already familiar with the basics, we have created a companion video, Insider Reporting Beyond the Basics, which explores additional reporting scenarios and highlights common areas where filing errors often occur. As a general reminder, the following information is intended only as general introductory information to address some common questions, and it is not intended to be and must not be relied on as legal advice. Please refer to the specific provisions of Alberta Securities law. We encourage you to seek legal advice from legal counsel familiar with Alberta Securities law. All insider information, company names, and details used in this video are fictional. Moving to today's agenda, we will provide a brief overview of what insider reporting is and the policy rationale for it. We will explain where to find the requirements and who needs to report and when. We will also take a walk through getting set up on the System for Electronic Disclosure by Insiders, or SEDI, to start filing insider reports, review sample filings, and then conclude with some of the common filing errors we see. What is insider reporting? Well, it is the legal requirement for certain individuals and entities, referred to as reporting insiders, to disclose their holdings of securities and their purchases, sales, and other transactions in securities of a reporting issuer of which they are an insider. The full definition of reporting insider can be found in National Instrument 55-104. But generally, reporting insiders are those parties that could have or be expected to have access to material, non-public information about an issuer. The rules in relation to insider reporting can be found in National Instrument 55-104, Insider Reporting Requirements and Exemptions. And guidance about the rule can be found in its companion policy, known as Companion Policy 55-104 CP. Both of these are available on the ASC website in the Regulatory Instruments section. The companion policy contains the policy rationale for why securities legislation requires reporting insiders to file reports. Firstly, the insider reporting requirements can help deter improper trading based on material, undisclosed information. It can also increase market efficiency by providing investors with information concerning the trading activities of the insiders of an issuer, and by inference, the insiders' views of their issuer's prospects. In addition, insider reporting also helps to prevent illegal or otherwise improper activities involving stock options and similar equity-based instruments, including stock option backdating, option repricing, and the opportunistic timing of option grants, also known as spring-loading or bullet dodging. This is because the requirement of timely disclosure of option grants and public scrutiny of such disclosure will generally limit opportunities for issuers and insiders to engage in improper dating practices. Insiders should interpret the insider reporting requirements in the instrument with these policy rationales in mind and comply with the requirements in a manner that gives priority to substance over form. So how do you know who needs to report? Not all insiders need to report, only those that are reporting insiders by definition. The definition of an insider is set out in the Securities Act, and the full definition of who is considered a reporting insider is set out in National Instrument 55-104. It is important to note that reporting insider is a subset of the broader category insider, and it is only reporting insiders that are required to report. Insiders should refer to the definition of the reporting insider to determine whether they are a reporting insider. However, a non-exhaustive list of some of those parties included in the definition of reporting insiders include the CEO, CFO, COO, and other parties responsible for a principal business unit, division, or function of the reporting issuer, directors, significant shareholders of the reporting issuer, and a significant shareholder refers generally to a party that owns or controls 10% or more of the voting rights. The definition also includes the CEO, CFO, or COO of the significant shareholder of the reporting issuer or of one of its major subsidiaries. It's important to note that it is not necessary that a person have a particular title to be considered a senior officer or director. If they carry out the function of a senior officer or director, they will generally be subject to reporting obligations. Similarly, the definition includes management companies providing services to the issuer and their specified executives, directors, and significant shareholders. In addition, the definition includes any other insider that in the ordinary course of business both has access to material, undisclosed information, and can exercise significant power or influence over the reporting issuer. And lastly, the definition includes the issuer itself, if, for example, the issuer were to acquire its own securities. It is the responsibility of the insider to assess whether they meet the definition and have a reporting requirement. However, issuers may wish to review the definition and roles within their organization to assist their insiders with identifying whether they have a reporting obligation and understanding their obligations. Some issuers will facilitate filing of reports on behalf of their reporting insiders. It is very important to remember that the prohibitions against buying or selling securities on material, non-public information are not limited to only insiders or reporting insiders. This presentation is focused only on the insider reporting obligation and should not be used to identify who is subject to the prohibitions on illegal insider trading or tipping. So, where to report? In our agenda, we referred to something called SEDI. SEDI is the acronym for the System for Electronic Disclosure by Insiders and is a web-based system for filing insider reports. It is available 24 hours, 7 days a week. However, there is a process to register for the first time to use the system. We will discuss that further on in the presentation. It's important to note that while the system is available 24/7, the registration process will typically take a few days, and so it should not be left until the last minute before you need to file a report. Let's take a look at the primary reporting requirements for reporting insiders. The obligation for insider reporting is applicable to all jurisdictions where the issuer is a reporting issuer. Full details of these can be found in Part 3 of NI 55-104. For instance, if you are the CFO of a reporting issuer, what are your reporting obligations? First, you are required to create an insider profile and report an initial opening balance report within 10 calendar days of the date that you first became a reporting insider. This initial report is required if you own securities, have interests in, or rights or obligations associated with related financial instruments of that issuer. Examples of the types of securities that need to be reported include common shares, stock options, RSUs, DSUs, warrants, or debentures. If at the time you first become a reporting insider, you do not have any securities or related financial instruments of the reporting issuer, you do not need to create an insider profile or an initial opening balance until you do own any securities or have such interests, rights, or obligations. However, you may choose to create an insider profile when you first become a reporting insider in anticipation of filing future reports. Subsequent reports will be filed if there is any change in reporting insider's holdings. The reporting insider must, within 5 calendar days of the occurrence, file a report disclosing the change in their holdings. It is important to note that the deadline is 5 calendar days, not 5 business days. The time period isn't extended due to holidays, and as mentioned, SEDI is open 24/7, so filings can be made at any time. There are certain exemptions that extend these timelines, some of which we'll discuss later in the video. We encourage reporting insiders to review the applicable instruments or discuss with legal counsel to ensure that they are meeting the deadlines specific to their circumstance. As we noted in the policy rationale earlier, one purpose of insider reporting is to provide timely and accurate information to the market. To help incentivize reporting insiders to report their trading activity or changes in beneficial ownership on time, some regulators impose monetary penalties for reports filed after the prescribed deadlines. A reporting insider of a reporting issuer that is headquartered in Alberta, or for which the ASC is otherwise the principal regulator, is subject to a late fee payable to the ASC if they filed a late insider report on SEDI. The late filing fee is $50 per day, per insider, per issuer, and is subject to a maximum of $1,000 per issuer per calendar year for each insider. The details are set out in Section 50 of the ASC Rule 13501 Fees. Reporting insiders of issuers whose principal regulator is a jurisdiction other than Alberta should consult the fee rules for that applicable jurisdiction. When filing reports, you will be required to identify the manner in which you hold the securities of the issuer. This is referred to as the ownership types. There are 3 types and are as follows. Direct, meaning that you hold the securities directly. For example, you hold them in an account with your broker, but the account is in your name. Indirectly, you hold the securities indirectly, which means that you beneficially own the shares in, say, Exco, but the registered owner is another entity, such as a holding company, an RSP, or a family trust. As a reminder, when listing the types of ownerships held in accounts such as an RSP or TFSA, do not list the brokerage firm names or account numbers. And the third type of ownership is control or direction. You will be considered to have control or direction over the securities if you directly or indirectly, through any contract, arrangement, understanding, or relationship, or otherwise have share voting power or investment power. This would include having control or direction over the securities through a power of attorney, a grant of limited trading authority, or a management agreement. An example would be if you set up a trust for your children in which Exco securities are held. You control the trust, and you need to report the trust's holdings in these securities. This may also be the case if your spouse, for example, owns securities of the issuer, but you have control or direction over those securities. As we mentioned earlier, there are some exemptions from insider reporting requirements or the reporting deadlines as set out in NI 55-104. We provide some examples, but caution that this is only a summary. The full text can be found in parts 5 through 9 of NI 55-104. You should review these exemptions in detail and may wish to seek legal advice to ensure you are able to rely on the exemptions in your specific circumstances. For example, Part 5 of the instrument contains an exemption for securities purchased under an automatic securities purchase plan that, generally speaking, allows reporting in respect of those purchases to be done by March 31st of the following calendar year, rather than by the normal 5-day deadline for insider reporting. And Part 6 of the instrument speaks to an exemption for issuer grant reports. This part applies to situations where an issuer has granted securities under a compensation arrangement such as options, stock appreciation rights, restricted shares or restricted share units, or performance units. Some issuers may choose to file an issuer grant report on SEDI that publicly discloses the details of the acquisition of a security of the reporting issuer under a compensation arrangement made to their reporting insiders. If an issuer has filed an issuer grant report within 5 days of the grant, then the reporting insiders named in the issuer grant report will have more time to report. Instead of reporting the grant within the usual 5 days, the reporting insiders will have until March 31st of the next calendar year to report the grant or award. However, if subsequent to the grant and prior to March 31st of the next calendar year, you dispose of the options or awards that were identified in the issuer grant report, you must file an insider report for the grant and the disposition within 5 days of the disposition. You are not able to wait until March 31st. Reporting issuers are not required to file an issuer grant report, so we caution reporting insiders to confirm that the issuer did in fact file an issuer grant report that included their grant and that it was filed by the issuer within 5 days of the grant. If the issuer did not opt to file an issuer grant report, or if it was not filed on time, then the reporting insider is subject to the normal 5-day filing deadline, and if they miss it, they will be assessed a late fee. Part 7 contains exemptions for normal course issuer bids and public disclosed transactions. Part 7 could be used if the issuer is an insider of itself. For normal course issuer bids, or NCIBs, the exemption allows additional time to report in certain circumstances. For other transactions involving securities of its own issue, other than an NCIB, the insider reporting requirement may not apply. We are mentioning this so you are aware of this exemption. You should review Part 7 of NI 55-104 in detail to learn how this exemption works. And Part 8 provides an extension to the filing deadline that applies to an issuer event. And an issuer event refers to a stock dividend, a stock split, a consolidation, a corporate amalgamation, reorganization, merger, or other similar event that affects all of the holdings of a class of the issuer's securities in the same manner on a per securities basis. Reporting insiders affected by an issuer event are required to report the effect of these changes, but do not need to do so until the next time they need to file an insider report. For example, if you're a reporting insider of an issuer that has recently completed a share consolidation, you may choose to wait until the next time you are required to report an acquisition or disposition or similar transaction relating to the securities of that issuer, and then report the consolidation transaction at that time. Part 9 contains exemptions that cover scenarios that are not specific to an event or an action by the issuer as the ones we described earlier. The more commonly relied upon ones in this section, where the insider reporting requirement does not apply, are to insiders of an issuer that is a mutual fund. In this case, if you are an insider of a mutual fund, you are exempt from reporting requirements as they relate to that mutual fund. And a nil report. Typically, the most relevant part of this exemption is that if you become a reporting insider of an issuer and have no holdings, you are not required to file a report that shows 0 holdings. There are several other exemptions in this section that may apply to your unique situation. To view the complete list of the general exemptions and the detailed requirement for each, please refer to Part 9 of NI 55-104. We have talked about what insider reporting is and who is required to report. Now let's take a look at how to report on SEDI. Some reporting insiders will retain a filing agent to file insider reports on their behalf. In other cases, the reporting issuer may agree to file reports on behalf of their reporting insiders. However, many reporting insiders file their own reports. Whether or not a filing agent or the issuer agrees to file on your behalf, Ultimately, it is your responsibility as a reporting insider to make sure that the report is filed. There are 2 steps to be taken before an insider can file reports for themselves on the system. First, they must register as a SEDI user and create an insider profile. Anyone who wishes to file reports on the system will need to register as a user. As we move forward and get into the registration process, we will see that you can register as an agent, a reporting insider, or as an issuer. If you register as an agent, that means that you're going to be able to file reports for other people. If you register as an insider, you would only file your own reports. And if you register as an issuer, you can file reports for the issuer only and create issuer profile supplements and file issuer events. Something to note, if you're an insider who does not plan to use the system yourself and expect to always have your reports filed by an agent, then you do not need to complete the registration process. The agent can create a profile on your behalf. While only those that are registered as users can make filings on SEDI, parts of the information filed on the SEDI system are viewable by the public through the website, and in that case, no registration is required for that purpose. Insiders, issuers, or agents wishing to file insider reports or make other filings in SEDI for the first time must complete the online SEDI user registration form. To access this form, navigate to sedi.ca and click Register as a SEDI user. As mentioned earlier, there are 3 SEDI user classifications. In our example, we have indicated that we are an insider who will file reports for ourselves. Again, just as a reminder, if you do not plan to file reports yourself and will use an agent, then you do not need to complete this form. Once you complete the form, follow the on-screen instructions to review the terms and click Accept. This will produce a summary of the form where you can certify if it is accurate, edit the information, or cancel the registration. Once you certify the form, you will receive a notice that you have conditional registration. The SEDI system will supply you with a unique user ID and password. It is important to note that the registration process is not complete and the account is not activated until a signed copy of the completed registration form is sent to the CSA service desk by email or fax. Activation can take up to 24 hours. The CSA service desk will email the SEDI user via the email address provided in the SEDI user registration form to let them know when they have activated their registration. If you have not received an email and would like to check if your account has been activated, you can log in with the user ID and password that was created for you and select View Your User Information from the navigation bar. In this example, we can see that the account is still in a conditional state and has not yet been activated. Once your account is activated and you log in for the first time, you will be presented with an insider homepage. If you have previously registered as a reporting insider of another issuer, you don't need to complete a new profile. In that case, you would already have a profile and an insider access key, and should use the option to link this user account to your profile rather than creating a new one. However, if you have never registered before, you will set up an insider profile. It is important to only have one profile on the system. For today's purposes, we will assume that you do not have an insider profile and will look at how to create a new one. This screen illustrates the information that is required to complete the setup. As a time-saving measure, you are able to copy the information from your registration form by selecting the first field on the form, and then you will also be required to create a confidential question and answer. The next step is to search and select the issuer with whom you are a reporting insider. If you know the issuer's SEDI number, you can use that. However, if not, enter the issuer's name and select Search. In our example, we searched and added the fictional issuer ABC Corp. Once you have added the issuer to your profile, you will be presented with another screen where you will use a drop-down list to select a category that corresponds to your relationship to that issuer. In this example, the person is a senior officer of ABC Corp and became an insider on January the 15th, 2026. After the insider profile is created and certified, an insider number and insider access key are created. You will want to record these in a safe location for future use. You are now ready to file insider reports. It is important to note that if at some time in the future you want to use a SEDI filing agent to file reports on your behalf, they will require your insider access key. Next, we will look at how to file some common reports. To file a report, log in using your SEDI user ID that was created earlier in the video when we registered as a user. It can sometimes be confusing for individuals who file for themselves to remember that they have both a SEDI user ID and password that allows them to file or use the system, and they also have an insider number and insider access key that is attached to their profile as an insider and identifies the insider and their relationship to an issuer. Next, select File an Insider Report from the options on the left. You will then be presented with a screen to select which issuer you were filing a report on, and in this case, we see that the insider is connected to only one issuer. But if Mr. Test was an insider of other issuers, we would see those here as well. Once the issuer is selected, then a list of outstanding securities for that issuer is presented. The issuer should have populated SEDI with all the types of securities it has issued. If you do not see the security listed that is required for your report, please contact the issuer and ask them to update their list. If this is an urgent filing and the issuer cannot be contacted, an insider-defined security could be created. It is preferable to only use this option in an emergency, and more information on how to create an insider-defined securities can be found in the help section of SEDI.ca. We talked earlier about the need to file reports that identify the type of ownership of securities held. As we see here, there is a drop-down menu where you would select the applicable ownership type for the report you are going to file. In this case, we will use direct ownership. When filers create their initial report for a new type of security designation or for a new ownership type, they will first be required to show an opening balance of the securities held in that ownership type. In this example, this is the first report of options that Mr. Test has filed and did not hold any options prior to becoming a reporting insider. If he had had options at the time he became a reporting insider, he would have indicated that number as an opening balance. You would then follow the prompts and complete and certify the transaction. After completing and certifying the report, we are asked if we want to file another transaction. For today's purposes, we also want to file a grant of options in Mr. Test's direct holdings, so we would select same security and holder. We are presented with a screen to enter the details of our report. In this scenario, we see a report on the grant of options with an exercise price of $1 and an expiry of January the 15th, 2027. The Nature of Transaction box has a drop-down menu with all of the available options to identify the type of transaction being reported. In this case, the nature of ownership code was a 50 grant of options. You would then follow the prompts to complete and certify the transaction. When reporting an exercise of options, or any transaction involving a security that converts or exchanges into common shares, it must be reported as a two-sided transaction. This means that first, a report is filed for the security designation options, reporting the exercise of the options. This has the effect of decreasing the balance for the number of options held. As we see here, 1,000 options are shown in the number or value of securities disposed of in the box on the right side of the screen. In the next screen, we will look at the second side of the transaction. The second part of the transaction is to report the securities acquired on the exercise. In this case, the options exercised into common shares. So the filer needs to report the common shares acquired and the resulting increase to the holding of those common shares. When presented with a securities designation, the filer would select common shares and proceed to record that reporting insider had acquired 1,000 common shares, as we see here. In the field for the nature of transaction, the code would be 51 exercise of options to show how the shares were acquired. We can also amend reports. If a filer reports a transaction and discovers an error, they will need to file an amendment to correct this. To amend a previously filed report, filers begin by logging in and selecting Amend or Delete Insider Report on the left side of the screen. If the insider is an insider of multiple issuers, you would be presented with a list of those issuers to select from. You can also narrow your search by applying a date range. Once you have selected your issuer, you then select Amend or Delete the Insider Report. You are then presented with a list of transactions based on the criteria entered for the search. So for example, you could select transactions made by date filed or security designation. From here, you would select the applicable transaction and the amendment type from the options listed at the bottom of the screen. Let's take a look at how to amend the details of a transaction. We selected Amend Details option for this transaction and are now able to amend the details such as the date, number of securities, exercise price, or expiry date. When the required amendments have been made, select Next. You would then be asked to certify the amendment. And it is important to note that if the date of the transaction is amended to a date that is more than 5 calendar days prior to the filing date, a late fee could be assessed. And there are various reports that are viewable by the public in SEDI and can be located by clicking on the Access Public Filings button in the upper right corner of the screen. From there, you can access the type of report you wish to see on the left, and then the report title by selecting the appropriate radio button next to it. In this case, we want to view summary reports and the insider transaction detail for the fictitious filer Kelly Test. Choose from the available filters, and in this case, we wanted to see everything that the insiders filed, so we did not limit the results by applying a filter. We can now see all of the transactions recorded for Kelly Test. As we come to the end of our video, we thought we would leave you with a few of the common areas where we see errors in filings. One of the most common errors is the reporting of securities that are exchangeable or convertible into common shares, as in our example of the exercise of stock options. Filers often forget to file reports for both sides of the transaction. As mentioned previously, when filing a report of the exercise of stock options, one report is filed to show the decrease in stock option security designation, and a second report must also be filed in the common shares security designation to reflect the increase to the common shares. We also see instances where filers are using the incorrect transaction dates when reporting grants of options. Usually, the Board of Directors resolution is the date that is the reportable transaction date. However, if this date precedes the date of regulatory approval or when you became aware of your allotment, the later date should be used for reporting purposes. And when filing the acquisition or disposition of securities in the market, the transaction date should be reported as the trade date, not the settlement date of the trade. And finally, as we noted earlier, there is a list of preset nature of transaction codes to select from when filing your report. The codes assist the market and regulators to understand the circumstances surrounding the acquisition or disposition of securities. Sometimes reports are filed using the incorrect nature of transaction codes. As an example, if a report was filed using a transaction code 16, which is an acquisition or disposition under a prospectus exemption, but it was actually a market purchase. It could be confusing if the issuer's disclosure did not mention that they were raising funds using a prospectus exemption. That brings us to the end of the topics for this video. We would like to thank you for your time and attention. We have compiled a list of links referred to in the presentation that may be of assistance in your insider reporting. These links are available by searching our website at asc.ca, the SEDI website at sedi.ca, or the CSA website at securities-administrators.ca. Thank you again for your time. We leave you with the contact information for the CSA service desk and our inquiries line should you require any further assistance.